Good morning. I'm letting people in from the waiting room. Just give us a minute to get started. I'm just going to wait one more minute because I see people struggling still to get in. But thank you, Samantha, Jenny, and Christine for joining us. I'm going to let everybody go around and introduce themselves if they want so that we can have a better understanding of why you're joining us today. And it just makes it more personable to know that we're all out there in the world. So Samantha, you have to unmute yourself. Everybody's muted. I'm going to go over a little bit how to use Zoom too. But Samantha, do you want to go first?
Sure. Can you guys hear me all right?
Yes, we can.
Yeah, so I work for Victoria and Realty Collective, and I've had the chance to see each of these presentations so far, and they've been really helpful and give me a ton of information. So I'm excited to see this one, and we'll be sending out some notes afterwards, so don't worry about missing anything.
Or taking notes. You don't need to take notes right
Right.
now. I'm going to go Jenny. I don't know if you have
Looks like she's connecting to audio.
Okay. Christine?
Hi, Victoria. How are you?
Good. How are you?
Good. I had missed the very beginning of your the audio hearing of what you were saying for introductions. I'm assuming this is what this is.
Yes, we're just saying hello because I'm sure it's like a small group of us, so it's always just nice to take the time if we're all going to get on a call together and give you some information. Just introduce yourself. So, where are you joining us from?
I live in Maryland. I'm located in Upper Marlboro, Maryland right now. And my husband and I, my husband's Air Force. And so I'm always trying to keep up with this legal information here. So thank you so much for holding and putting this meeting together. Thank you. We really appreciate it.
Oh, no. Thank you for coming and joining us. I think this is like information that before I started working with Jessica, I was very unaware of that I need to do these things, especially as a small business owner. My husband works for, DOE? And so we have some of the stuff covered because of the union, but really, some more people are joining us. This was all, I learned a lot just from participating in this because it's stuff that is, we all avoid in normal life. And now we're sort of, our hands are getting forced. So thank you. And I'm going to go around and there's a couple more people joined us. So I'm going to go around and let you introduce yourselves. There's Christina. Jacob? You can unmute yourself and introduce yourself.
Hi, I'm Christina. I work with Brown Hair Stevens.
Hi, Christina. Nice to meet you.
Thank you.
There's Leslie.
Hi, it's actually Ann Garrison. Just thought I'd tune in and find out lots of interest in our family about possibly setting up a trust.
I think that might be good, Jessica, since this is a short presentation, maybe we do a little recap of the last two, just, what we've already covered, and that, if people have questions about that, they can reach you after
Sure.
this. So I have Jenny still having a trouble with sound. Sally?
Yep. Hi, thanks for offering this. Similarly to Anne, looking for more information about setting up a will and trust. Thank you.
You're welcome. Thanks for joining us. So my name is Victoria Alexander. I'm the owner. Oops, there's more people joining us. Okay, letting them in. My name is Victoria Alexander. I'm the owner and founder of Realty Collective, a small boutique firm here in Brooklyn that focuses on small business, small landlords, mom and pop stuff, and that has been dedicated to defying the stereotypes associated with real estate brokers now for 15 years. And I think I've done a pretty good job at that. And we have started working with Jessica a couple years ago because she moved into the office next to mine when I still had a different storefront. And she's been a really great asset and resource as a trust and estates lawyer for my clients. And I just think this is information at a very pertinent time in the world that we have most people avoid, and that it'd be good to have the information so that you can, take care of things that you don't want to leave untaken care of for other people and for yourself also too. So we talked about a couple different things. So I'm going to introduce Jessica. If anybody, well, quickly let me go over some Zoom tutorial. There's a chat at the bottom. You can type any questions you want in the chat. We're going to try to hold questions to the end and then have a open conversation with everybody. So you have free time to talk with us. Next to your name under participant, you can raise your hand if there's something you want to ask immediately. And so if anybody needs help with the chat or with Zoom, just message me directly. I'm going to be assisting on the technical side and let Jessica speak on the topics. So I'm going to turn over to you, Jessica, and I'm going to let you maybe cover what we're going to do today, but then go over quickly what the past 2 sessions have been on so that people know what we've already gone over and what you're available to advise on.
Okay. All right. Thank you. Hi, everyone. I know this is not a topic everyone likes to talk about. It is always a relief for my clients when they finally do this. And every single one of them that comes into my office says, oh, I've been planning to do this for so long. So it is a relief. And even if you're just gathering information at this point, I'm happy to help. I am a trust and estates attorney in Brooklyn. I have a neighborhood practice, so I'm very involved in my neighborhood. And since COVID-19, I've been doing more webinars because all of my meetings are now via Zoom. We are lucky enough in New York State to be able to do all of our estate planning with our clients remotely. And this is only in place until June 6th, though it might be extended, I'm not sure. So we had a couple of prior webinars. One was regarding whether you really needed a will. There's a lot of do-it-yourself wills out there, and basically we talked about who doesn't need a will. One of the people that I said, who does need a will would be couples with children. It would really be the simplest estates that would not need some type of will or trust. I believe one of the examples we gave, if there was just a husband and wife leaving it to each other, no children, that would be a very simple way, simple estate plan, and you wouldn't necessarily need a will for that. But if you do have children and a spouse, if you do not have a will, basically what happens is your spouse gets first 50,000 plus half, and your children, even if they're adult children or children from a prior marriage, get the other 50%. But obviously it was a whole webinar about that. What was our first webinar, Victoria? Oh, I can't hear you.
About health proxies and power of attorney. And
okay.
a couple of those things that you went over that I thought was really informative, especially in this time.
Sure. So we talked about advanced directives. So the 3 main advanced directives people talk about are the healthcare proxy, and that is when you name an agent to make medical decisions for you if you cannot do so. And that would be in all kinds of different circumstances. If you were intubated, if you were in a coma. There's a living will, which is the roadmap for your agent. Basically, what would happen if you were in a vegetative state? It's basically an end of life decision. Would you want to be kept alive by artificial means? And the third would be the durable power of attorney, which has turned out to be pretty much the most important document anyone could have at any age. And that is when you name a fiduciary to make financial decisions. However broadly you would like to define that depends on the terms of the power of attorney. So that's what we had talked about previously. So today I am going to talk about the revocable living trust and why all of a sudden, out of nowhere, I am telling people this might be something to consider, which I would not have told many of my clients this in the past. I don't know if you watch Susie Ormond. She is somebody who's on TV and on the internet, and she provides information on estate planning. And she's one of those people who is like, everybody needs a trust. And I always made fun of her, but it's not true. Not everyone needs a trust. But I have to say there might be more reasons to consider it now. And that is because we have been in a state of emergency since March. And the courts have been closed down since March 17th. And I mean, not closed down completely, but closed to new matters for sure. And everything has been delayed and backlogged. So let's see, I have a PowerPoint, which keeps me on point. So I'm going to share that. Okay. Okay. Okay, so first I'm going to explain what is a trust. A trust is basically a retitling of assets. Most people think of a trust, they think, oh, rich people, trust funds, but that's not necessarily true. Many people have trusts that are not wealthy or not wealthy like you're thinking. And basically all it is retitling. So say you have a trust brokerage account. That is a retitling of that brokerage account from your name to your trust, the John Smith Revocable Trust. That's who would own that. Now it is a separate entity than yourself, and that is used to hold, distribute, and control your assets. Now, you basically are the settlor or the grantor or the trust maker, different terms, and you appoint a trustee to manage the trust, and you are going to put terms in that trust, just as you would in a will, how you're going to disperse income and principal. So some of the terms you see when we talk about trusts are written right here on the PowerPoint. Basically, a revocable trust versus an irrevocable trust. Now, starting with the irrevocable trust, it says it's irrevocable. That's not necessarily true. There are very few irrevocable trusts that are truly irrevocable. The definition I put here is that they cannot be modified, amended, or terminated without the permission of the beneficiaries. So say you have an irrevocable trust and you name your children as beneficiaries of the principal, and you decide that, listen, these kids are no good, or they're spendthrifts and I want to take the money, I don't want them to get the money, you could run into issues there because you'll need their permission. There's also something called decanting, and that is a way we can modify trust. And there's all different ways to decant. So it depends on your circumstances, but usually we can decant a trust and give broader terms. Now, a revocable trust means that the grantor retains the ability to revoke on his or her own, and the assets can go back to the settlor, the grantor. Now, the grantor settlor in a revocable trust is usually the grantor and or the spouse. And when we talk about a grantor trust and a non-grantor trust, these are tax terms. So, for example, if you're retaining enough control over the trust, according to the grantor trust rules in the IRS, from the IRS, IRC 671 to 679, that means that you've retained enough control in the eyes of the IRS to have any of the income generated from the trust, think stocks or rental property that's in there, taxed to you at your income level every year. So usually this type of trust will use your social security number. Doesn't have to, you can get a tax ID number for a grantor trust. You don't have to, but you can. And basically, that's a good thing for most people, because if it's a non-grantor trust, meaning we did not trigger any of the grantor trust rules, which I believe I have some down here, the right to change beneficiaries, the right to borrow without adequate security, the right to revoke. There's a whole list of them. If one of these triggers, if one of these grantor trust rules was not triggered, then it would be a non-grantor trust, which is valuable in other ways. But basically that trust would become its own entity, have to have a tax ID number, and would not be taxed at the grantor's tax rate. And right now, that's about 37% is the trust tax rate. So the trust would, so in order for that to make sense to an individual, simplifying this, but in order for that to make sense, that would mean that the grant maker would already be being taxed at that tax rate. But what I'm talking about today is a revocable living trust. also called an inter vivos grantor trust. So this is basically a trust where you would set one up and you would be your own trustee. So you would be in charge of all the money and any assets you decide to put into that trust. And you could also be the beneficiary of the income, like we talked about, but also of any principal. So let's talk about what it does and what it doesn't do. So it avoids probate, and that is the most important thing today for any assets that are in the trust, meaning you do not have to go to surrogate's court. You are saving time and you're saving money. It depends on the assets in your trust, how complex your estate is regarding if you did not have a trust and you were going to probate your will, or if you didn't have a will, if you were going to administer the estate, the cost of that could be anywhere from the lowest end of $1,500 to, upwards of $50,000. It just depends on your estate. So it avoids probate. It allows the settler to control the assets throughout their incapacity. Say if they were to become incapacitated at some point. Once you name yourself as trustee, you're also at that time going to name a successor trustee. And that could be a spouse, that could be somebody you trust, like a sibling or even a financial advisor or an attorney, to control your assets in a way that you're setting forth in the document for later, for decades in the future. It also could be set up to give you asset protection. So say that example I have is the HEMS standard, another IRS term. This is when you're able to get all of the income, like we talked about with the grantor trust, and as much of the principal as you may need for health, education, maintenance, and support. That gives you creditor and divorce protection. So you could build that into it. Privacy. All wills are public record. So if privacy was a concern of yours, the trust is better for that. Reduce interfamily conflict. It is much harder to contest a trust than it is a will. So if there is somebody who you want to disinherit, I've always said, well, the trust is the better vehicle for that. So you could do that. It's not impossible for somebody to contest the trust, but it is much harder when you have to, if you have, say, a child that you're disinheriting, or you have, say, a sibling who you think is going to come after your estate, they could get in the mail as a distributee of your estate because of their familial relationship with you, a notice in the mail asking for them to appear at a court date. So that makes it a lot easier for them to just go into court and contest the will. Again, simplifying it. One of the other things that it accomplishes is continuity. And I think this is what you were talking about, Victoria. If you have a business and you're leaving your business to somebody in your will, or you have rental property that you're leaving, that you own in your sole name and you're leaving to your heirs, what happens if the courts are closed for months? That business is in limbo. So for continuity, you would name your successor trustee at your death, and that would eliminate, it would be a seamless change. It would eliminate the need to probate in order to get the executor or to get a separate trust set up, however it's set up, but continuity is big. Also, another big reason would be avoiding ancillary probate. If you own real property in another state, you would have to probate a will in that state to dispose of that property. And if you title it in the name of the trust, you wouldn't have to do that. What a revocable living trust does not do is does not avoid or reduce estate tax. That is not what we're talking about today. So it does not do that. There are other types of trusts that could do that, but not this one. And it's not going to avoid probate for assets that are left out of the trust. So say you don't put all of your items in this trust, the other assets would still have to be probated. And if you only put your important assets into the trust that you needed continuity for, that could work. Or you put all of your assets into the trust and every other account you have hold either jointly with somebody else, or there is a beneficiary that is non-probate assets. So an IRA, a 401k, life insurance, those never have to go through probate. Those you name a beneficiary, you can name a beneficiary and a contingent beneficiary for the most part. Why doesn't everyone do a trust? 2 reasons. There might be more, but 2 reasons I could think of. They're more expensive to set up. Probably 3 to 4 times more expensive than a will. So there's that. And but like I said, the money would either come out now or when you set up the trust, or later when your estate would be probated if you have a will, or administered if you don't have a will. And there's also more upfront work. You would have to do the retitling. You would have to go to the bank and show them the trust and say, okay, I'm retitling this. So those would be the 2 drawbacks. This, I was talking about what is actually going on in the courts. So I just read yesterday that some upstate counties are opening. So I expect to have more court matters opening up, more surrogates courts opening up upstate, but I didn't see in Ulster or Sullivan counties, which are the closest. So right now, even before Governor Cuomo's order to shut down on March 17th, all non-essential matters in the New York courts were adjourned. And they only were and are looking at urgent and essential matters. Basically, surrogates court depends on the county. Nobody defined what is an essential matter for surrogates court. We have, nothing can be, well, let me say, we have to go, it's actually by county. So let's look at this. So I'd say the best right now would be New York City. That means somebody who resided in New York City at the time of their death. New York City Surrogates Court is accepting uncontested matters. That means that there's a very simple estate where everyone is agreeing. So everyone is signing waivers and there'd be no need of scheduling a court date. So that is happening in New York. That has to be sent in by mail because they do not have e-filing. Also the Bronx, I wasn't unaware of this, but I guess they're doing it. I went to their website. They're also accepting uncontested matters, but nobody else is. So again, urgent and essential matters, Kings County, they are saying that if it's an essential matter, you have to have an affidavit of urgency, basically saying, why is this is so essential? This costs more money. I haven't done one. I imagine that there's circumstances where you would say probating this will or administering this estate is an urgency, maybe because there's children involved and you need to name a guardian, maybe because there's a business, but that's certainly not going to be something that happens quickly, even if the court decides it is an essential matter and allows you to submit a petition. So depending on the county, Suffolk County, they're not accepting any new matters, but you can send them in. They're not looking at them, they're accepting them, and you're just basically waiting in line. And that's a good one because there's e-filing. Again, by county, some e-filing in New York County and in Kings County. I actually go to the surrogates court when I submit a petition. I have to go. I mean, it's archaic, but that's the reality. So as you could see, the different counties are doing different things, but mostly are not accepting new probate matters. So
everything's on hold right now in that regards, I guess.
Yes, everything's on hold. So it's creating a backlog with everything. So for example, I'm still waiting on letters to appoint my executor on documents I sent in January. I have to keep calling them because it seems ridiculous that we've been waiting this long, and it has really negative effects because the family wants to sell this house.
Right. That's what I've been really wondering, because people have been asking us about the market and things like that. And I had a very dark conversation about, the amount of estate sales that are probably going to be the real opportunities for people that are looking for a dip in the market. One, because obviously they're probably in a state condition, and they hadn't planned on, this liquidating their home asset. And two, that just, who's been passing from, unfortunately, through COVID. And it's just really a dark conversation, but it's also being held up because there's the wills and everything and trusts that are outlining all this, nothing can move forward because everything's being held up. So if they want to sell the house, they don't even know what the will says in some cases because they can't have access to any of this stuff. So I know that it's super complicated. This sounds very frustrating to be waiting so long, and being in this holding pattern, especially, if you're trying to mourn and other things at the same time and want to be moving past this experience.
Sure, there's the emotional aspect of wanting the closure, getting this over with. Imagine this keeps going on and you don't get along with the other people involved.
That's the one thing I always say, just with all of this estate stuff, is what's super important to make sure that people are educated on it, is to have this stuff all worked out so it has as little negative effects on your family afterwards. Because I've seen so many situations where it has really torn families apart, them fighting over their property. We have to sell the house and they're fighting over things. One, because everybody's emotional, or two, because things weren't laid out very clearly and easily for them, so that it was very direct, and it caused a lot of miscommunication and hurt and things like that. So I think that I've learned a lot of lessons, that it's super important to have your ducks and everything in a row so that your issues do not then have negative impacts after you're gone beyond what you can control. And if you can control that, I think it's super important, because can be I've watched it be very, very destructive situation, especially when people are selling, what they think are gazillion-dollar properties in Red Hook, in Brooklyn. So this is really interesting. Like, for me, this is super interesting to hear about, the ramifications.
And the trust can avoid it.
Right. The trust can avoid it. The trust can avoid it. Having a will, having things in writing. You need to have a plan and talk, and that's it. Especially if it's complicated. It's not simple. If you own multiple properties, people in my office, the agents that have worked with some of these families, they had 10, 20 different buildings, and the children just tore each other apart, unfortunately.
Nobody likes to have this conversation. I tried to do intergenerational family meetings. It's something I started doing maybe 6 months ago, just to sort of get everyone to sit down. And it's usually mom and dad are perfectly comfortable talking about how they're going to pass down their assets. It's the kids. They're so uncomfortable. They don't want to come off as greedy. It's something like, inheritance is a dirty word. So it's not, and it makes sense to talk about it. So in a lot of ways, people want to do trusts because it does teach their children, how money should be passed down, or how they want to have money passed down. Just like you can create a testamentary trust in your will, basically leave your children money in a trust that's created at your death. You could do that, and you can put some controls on that. And if you have a living trust, they could see how that's working before you pass away. So I think that's an interesting look on it. It does teach people to value money, or value family, and how you're keeping money in the family.
Right. That was the other thing we talked about at the first discussion, was living wills too, which I think that was a really important conversation, just knowing about like how you want your end of life care to be played out, and what your wishes are, and all that kind of stuff. And I think that was something I also, now in the time of COVID, realized that it was super important to have before all this stuff happened. So I didn't realize there was a difference between a living trust and a living will, and I learned all about that from taking these classes.
Yeah, and I can't stress enough that it's not the older generation that's uncomfortable talking about it. They want to talk about it. So like you said, I've had phone calls this week, right? Just this week, my mother died. We have her house, right? We're in the house. There's a mortgage to be paid. How are we paying this mortgage? How are we paying the utility bills? You have to carry that cost until you can be appointed as administrator or executor of this estate. So, you know, some people can carry it for a few months, but now you're being asked to carry it maybe for longer. I don't know when everything's going to go back to normal. And
Well,
also
and then,
backlog.
right. Well, and then that was the other thing, because I had thought about it a while ago when I had a business partner about getting life insurance, so that if one of the partners of the business passed, that they could buy their portion of the business from the inheritors. So it was something we thought about, but once I didn't have a business partner and I bought her out, I don't have life insurance.
So,
But I think that I probably need it so that my heirs could close the business, right? They'd need money to they couldn't operate the business without me because of licensing for real estate, but they would need funds to liquidate the business and pay whatever debts and, responsibilities or contracts, exit strategy for, leases and stuff like that. God forbid anything happened. And I just haven't thought that far ahead. And these are conversations I need to be thinking about.
I know a guy.
You know a guy.
It's actually a woman, but
Yeah.
so I mean, this is off topic, but I was surprised to learn that you can do your life insurance right now, even though they're not sending nurses out. She is getting life insurance policies approved. So a lot of people are looking into that now. And that is indefinitely, I ask all of my clients now, especially ones with children, do they have life insurance? Many do, and that's their biggest asset.
Well, Jesse does because he's a teacher, and so it comes with the union benefits. So that's why, but that's something I need to do independently. So I think that it's a full discussion with all of these things taken into consideration, especially because I own my own business. But are we open for questions, or we have another slide?
Sure, go ahead. I mean, I think that we talked about basically how this negatively impacts estates and families. I don't know if you've heard this, but they seal apartments, right? So if somebody dies alone, lives alone, the police will seal that apartment and you'll have to go to court to get it unsealed. That's just one of the effects that this COVID-19 shutdown, one of the effects of it. And yeah, no bequests, right? And here's something I learned actually, the property needs to be sold. So say you already had most of your will probated, you even got the letters of administration. So you had an administration letters testamentary for a probate, and you're ready to sell the property as the executor. Title companies want updated letters. And I think they have to be like 6 months, within the last 6 months. And how are you going to get those certificates all of a sudden? The courts are closed. So there's just a lot to think about. And if you have any complex property or assets that need continuity, this might be something to consider. So yes, I'm open for questions if anyone has any.
Anybody? Oops, I'm seeing people mute themselves. So if you've unmuted yourself, first person, Christine.
Yes. So Jessica, first of all, I just want to say I'm so sorry about the passing of your mom, the loss at this time. I know it's very hard, and these conversations are very hard to talk about, but they're just so important, and these legal aspects are just so important as well. And Victoria, like you were saying, having all your ducks in the row really does make it so much easier to kind of go through at least the paperwork process of these things when it's all put together. For question-wise, I was wondering for the trust, the revocable living trust itself, how long is that good for?
Forever, until you pass away. So, I mean, there's different ways of doing it. Basically, you can have the trust continue. Sometimes we'll have it continue throughout a spouse's life. But after the grantor passes away, it becomes irrevocable. So we usually have spouses do their own, but certainly you could set it up that way to continue on. It just depends on how you set it up. And wait, I think there's a misunderstanding. My mother did not pass away. If she's watching, sorry.
I'm so sorry.
Alive and well. But thank you.
Okay. I was also confused. I was like, wait, did Jessica's mom just pass? Like, I missed
I
that
didn't.
part of the story.
No, she's alive and well.
Okay, good.
Okay, good.
Yeah.
And what was the second question?
So the second question is with the trust. I have a question with you were talking about legal paperwork and having things in writing. How about power of attorneys? Having that with your trust, will that also help protect you? Especially when you have a small business and, you know, with your partner, with your spouse, and, you know, one were to pass, would that protect you as well?
Sure. You could do it either way, or both in tandem, like you said. If you have a robust enough power of attorney with every single power, or the power to control a business, that could certainly work.
Okay.
Uh, if you have it in the trust, they could be a successor trustee.
Okay, great. Thank you.
Looks like there's a question from Leslie that says, I'm in Virginia. Can you generally address what differences there may be executing a revocable trust in areas other than New York?
I cannot. But I am happy to send you a colleague's information, an elder law attorney, estate planning attorney in Virginia.
Good to know. What's the range of the cost to set up an annual carrying cost of a revocable trust, living trust?
So there shouldn't be really carrying costs from it unless you have a professional as the trustee. So say this type of trust, you're usually the trustee. So there shouldn't really be too many costs. The original cost to set up, I don't really want to get in trouble with, I don't know what everyone charges. So I would say minimum $3,500 for a trust, and they can go upwards. I would say for the most part, somewhere between 3,500 and 12,000 would be a range. It all depends on the complexity.
And the fees might be like having a bank account fees, like would be some possible, right? If you had a trust, wouldn't you have a bank account in the trust? Or no?
Sure, and these would be the same that you would have anyway.
Like normally, they'd be normal like banking and finance fees for accounts. Okay. I don't see any other questions in the chat, but is there anybody else on the call? A couple people joined us late. So Yuko or Glenn, do you have any questions about that you might have missed in the first part of the conversation?
Hi, Glenn.
Hi, Glenn. I can turn off your video for you. You got it? Do you want to ask any questions? Yuko said she's fine.
Okay, well, thank you, everyone. I know this is a difficult conversation, but maybe this gave you some information to start the conversation with family members or to give you a better idea whether a will or a trust is better for you.
Yeah. And if there's any follow-up questions, we're going to send a follow-up email with our contact info. Feel free to reach out. We're happy to help in any way that we can. Even if it's out of state, like Jessica said, she's happy to refer you to an associate that can help you. So everybody stay healthy and reach out if you need anything. Take care.
Yeah, take care.
Bye-bye.